Case 11. Friedman, the plaintiff, versus the FAA, the defendant. For this case, we find ourselves in the U.S. Court of Appeals for the D.C. Circuit. Starting with the facts. For the second time, Eric Friedman, a type 1 diabetic and aspiring commercial pilot, challenges the FAA's refusal to grant him a medical certificate required for commercial flight. Because Friedman uses insulin to manage his blood sugar, the FAA required him to submit data from a relatively new method of blood glucose testing known as continuous glucose monitoring. We'll call that CGM from here on out, which Friedman declined to provide. In a prior decision, our court held that the FAA had not borne its burden of justification for requiring CGM data. On remand, the FAA explained that it needed the data because CGM is able to detect hypoglycemic episodes often missed by more traditional monitoring, and it supported that explanation with medical studies in the administrative record. Friedman held a special issuance third-class medical certificate. After receiving Friedman's application to upgrade his certificate to first class, the FAA requested blood glucose testing results either from finger stick testing, which involves pricking a finger and using a glucometer to test extracted blood, or, if applicable, from CGM, a newer and less commonly used method of blood glucose testing that measures glucose levels continuously using a subcutaneously inserted sensor and a small wearable device. In response, Friedman provided only finger stick data, explaining that he does not use CGM. Over the next several months, the FAA again suggested and later demanded that Friedman provide CGM data for a minimum of 90 days, eventually warning that failure to do so would result in denial of his application. Friedman reiterated that he did not use a CGM device because neither of his treating physicians has found the device is clinically indicated or medically necessary. Friedman also pointed out that the ADA expert panel had recommended against CGM's use due to its tendency to record transient postprandial spikes in glucose levels, which are of no clinical significance. The panel itself wrote in support of Friedman's application, stating that although CGM is useful in identifying trends in blood glucose levels, it is less accurate than finger stick monitoring and thus neither necessary nor appropriate for medical certification decisions. Unconvinced, the FAA informed Friedman that it was unable to proceed with his application until it received the information previously requested. Friedman then filed a petition for review in this court. So here we are. What's the issue now? Whether the FAA's denial violated the Administrative Procedure Act, the APA, and the Pilot's Bill of Rights. The holding. The court denied the petition for review. In doing so, they took the FAA at its word, that it is working to develop an evidence-based framework to allow special issuance of first and second class medicals to certain insulin-treated diabetics, and that should Mr. Friedman's CGM data corroborate his assertion that he does not pose a risk while he is in the cockpit, he will receive a certificate. So the reasoning behind this case. Congress has directed the FAA to promulgate regulations that promote safe flight of civil aircraft, and to discharge this obligation in a way that best tends to reduce or eliminate accidents in air transportation. Specifically, Congress has instructed the FAA to ensure that pilots are physically able to perform the duties related to their position. To implement this directive, the FAA requires pilots to hold medical certificates of one of three classes. Pilots who fly commercial airliners must have first-class medical certificates. Pilots who otherwise fly commercially must have second-class certificates, and pilots who fly privately must have third-class certificates. In keeping with Congress's instruction that the FAA consider the duty of a commercial air carrier to provide service with the highest possible degree of safety in the public interest, the federal air surgeon to whom the FAA administrator has delegated his medical certification authority has adopted more rigorous medical standards for pilots who fly commercially, first and second class, than for those who fly privately, third class. FAA regulations further provide that at the discretion of the Federal Air Surgeon, the agency may grant a special issuance medical certificate to any applicant who shows an ability to safely perform all authorized duties to the satisfaction of the air surgeon. Pursuant to this authority, the air surgeon has awarded special issuance third-class medical certificates to some insulin-treated diabetics, a practice that has led to no medically related accident, incident, or in-flight incapacitation from any cause. The primary danger of flying with insulin-treated diabetes, the FAA has explained, is the risk of hypoglycemia, a state of abnormally low blood glucose levels, which is common among diabetics, especially those who use insulin, and which can impair a range of cognitive functions, including reaction time, memory, problem-solving, and spatial reasoning. In determining whether the FAA had satisfactorily provided such justification for its demand, the court was guided by well-settled principles of administrative law. It looked to see whether the agency had examined the relevant data and articulated a satisfactory explanation for its action, which may not neglect any important aspect of the problem, run counter to the evidence, or be so implausible that it could not be ascribed to a difference in view or the product of agency expertise. Here, although the court did not, as in Friedman 1, supply a reasoned basis for the agency's action that the agency itself has not given, the court decided that it could uphold a decision of less than ideal clarity if the agency's path may reasonably be discerned. It is important here to know the relatively low bar over which regulators must pass to win this case, reasonableness. The court easily disposed of Friedman's claims under the Pilot's Bill of Rights. That statute provides in part that the goals of the FAA's medical certification process are to give medical standards greater meaning by ensuring the information requested aligns with present-day medical judgment and practices, and to ensure that the application of such medical standards provides an appropriate and fair evaluation of an individual's qualifications. According to Friedman, this provision required the FAA to align its requests with present-day medical judgment and provide an appropriate and fair evaluation. That, of course, is precisely what the FAA, as required both by the court's remand and the APA, has now done. And the judges think it quite obvious that the Pilot's Bill of Rights, aspirational goal-setting language, creates no additional obligations.